I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, you know what time it is. We are jumping into number 193. We will be in 4 different judges' courtroom for this compilation. Before I give you the name of those judges, don't forget commentary will be left in for the previous proceedings that have aired on this channel that will be in this compilation. Also, chapters will be added for your convenience. Don't forget to like, comment, share, and subscribe. It is much appreciated. And now let me give you the rundown of the judges' courtrooms that we will be in on today. Now, the first judges' courtroom we will be in is Judge Brenda Dominy out of the state of Texas. Second, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas. Third, we will be in the courtroom of Judge Michael Chungin out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Victoria Shackelford, also out of the state of Michigan. This is 193. I hope you guys enjoy. Let's go ahead and jump in.
Sit in that first chair at the front. Have a seat right there. Morning.
Are you on the Constitution, Sheriff?
Do what, Mr. Jones?
Are you on the Constitution?
Yes, sir.
No, we don't. If you was on the Constitution, why did you refuse to accept a complaint attempted to be filed by me, called in your office 2 or 3 times?
Mr. Dennis, remember everything you say can and will be used against you in the court of law.
I'm under the Indian authority.
Okay.
Yeah. And also, since this being recorded, the United States has been dissolved. The courts, the police, the whole 9 yards has been dissolved. I'm under Indian authority. That's who have authority over me. Not expired, dissolved corporation. So this your refusal to accept my complaint, what resulted to this day in Jacksonville, Texas. You will not accept the complaint. Sheriff, I called your office and I talked to you personally. Up under 22 USC 912. Are you familiar that the United States corporation has been dissolved, Sheriff? Under 28 USC 912, and the police officer acting under the corporation of the United States vacated his oath and is acting.
Remember, everything you say can and will be used against you in the court of law.
According to 28 USC 912, any police officer acting under the corporation of the United States vacated his oath and is acting in an individual capacity as an illegal security guard operating under an illegal government. In a non-constitutional court, in proceedings, do not have the authority, and it's arbitrary. I am a sovereign American Indian. Therefore, this court do not have jurisdiction. So I'm requesting to be brought before an international court with jurisdiction, custom, and I'm protected under unit drift and A drift.
Mr. Dennis, the arraigning judge will visit with you here in a second.
The judges are dissolved by the presidential notice to the patrons on January 4th, 2025. Are you familiar with that, Sheriff?
No, sir.
Well, it is, and I ask that you look into it. The corporation is dissolved.
Yes, sir.
Yeah. The courts, the police, the judges, the sheriffs, all having been dissolved by President Donald J. Trump, before Attorney General Pam Bundy. So you're acting illegally, unlawfully. So what 5-0 consent have you been given authority from? Because this is an illegal government. And the arrest has been ordered by the president himself because of this breach of oath of office. So I do not consent to these proceedings. They are illegal and unlawful. If you're not, we are under common law 1776 as defined under Magna Carta 61. Are you recording this, sir? It needs to be recorded. Yeah. So, Sheriff, you're acting illegally and unlawfully because all departments has been dissolved. January the 4th, 2025. And I'm an American Indian. I'm not under the same laws, rules, regulations, and codes and policies that you are. And that is not law. Not only have you committed treason, you've been found guilty of crimes against humanity and war crimes. Now, a corporation do not have authority over natural human man. It's Penhollow versus Don Administrator. Also, Rodriguez versus Donovan.
Mr. Dennis, will you please stand up? Will you stand for me?
My back is stuff messed up, man.
My help, okay?
This arm is broke. Stand what? I'm not before no.
Stand right there. All rise.
Your Honor, are you aware that the United States Corporation has been dissolved by the President on January the 4th, 2025, and that I'm American Indian and you have no jurisdiction over my... Okay. No corporation has jurisdiction according to Penhollow versus Don, and also Rodriguez versus Donovan.
Okay.
So you've been found guilty of treason by the courts. And,
Mr. Dennis, you're Bobby Michael Dennis?
I do not consent to these proceedings.
Okay. I have to go. I am Judge Domini. I'm going to go ahead and read your rights.
I do not consent to these proceedings because the corporation has been dissolved, ma'am.
Okay. I have to read your rights to you by law, okay?
I do not consent to these proceedings, ma'am, because the corporation has been dissolved January the 4th, 2025 by President Donald J. Trump.
I'm going to go ahead and read your rights to you, Mr. Dennis. You have the right to hire an attorney to represent you. You have the right to have an attorney present prior to or during any questioning. by peace officers or attorneys representing the state.
I object to be.
You have the right to
I
remain
refuse
silent.
consent.
You're not required to make a statement. Any statement made by you can be used as evidence against you in court. You have the right to stop any questioning or interviewing at any time.
I'd like to stop it now because you don't have any authority
You have the
over
right
me,
to
ma'am.
have an examining trial if you're accused of a felony.
The corporation is dissolved.
You have the right to request appointment of counsel if you cannot afford counsel.
Do you not understand that the United States Corporation is dissolved up under 3002-15A?
Do you understand those rights
No, I
that
do
I
not.
just read?
I do not.
Would you like for me to
I still
explain
do
to
not
them again?
understand because I'm under God's law, not the laws of man, ma'am.
Okay. You have the right for an attorney if you cannot afford one. You have the right
I
to
do not understand, ma'am.
request an attorney. You have the right to stop any question at any time.
I'm attempting to stop it because the United States Corporation has been dissolved, ma'am, by the President on January the 4th, 2025. That will be a Saturday.
Okay.
And also, you being a corporation do not have a rights over a living natural man. I am a living natural man, ma'am. That's under Penhandler versus
Mr.
Bond
Dennis, I
Administrator.
am by law reading your rights.
Are
I'm
you-
going to go ahead and tell you.
Do you have the authority
I'm going
from
to
the
go ahead
Indian
and tell
Authority?
you what you're being charged with, okay?
I do not understand
by
the
law,
consent.
I have to do that, and I'm going to give you your charges,
You're not under
okay?
constitutional law, ma'am. So
Interfering with public service animal, state jail felony, you have a bond in the amount of $100,000.
I do not understand. I do not
Attempted
give
capital
consent.
murder of a peace officer, that's a felony 1, and it's a $1 million bond set on that. Obstruction or retaliation, felony 3,
object.
$150,000 bond. Another obstruction or retaliation of felony 3, a $50,000 bond.
I
And
object,
there is
Your
a
Honor.
federal
I don't-
hold on you for a federal
I don't
offense.
understand. Well, up under 28 U.S.C. 912 said any police officer acting under the corporation of the United States vacate his oath and is acting in a individual capacity as an illegal security guard operating under an illegal government. This is what this said.
Okay.
Yeah.
So do you want to request an attorney, or do you plan on hiring an attorney, sir?
No, I do not give consent. This corporation has been dissolved again,
Okay.
and that
I will tell
this is
you at
acts of
any
treasons.
time, sir, at any time, if you do not hire an attorney, you can request that the
I
court
do not
appoints you an
consent
attorney.
to a dissolved
Okay.
corporation.
I do need you to
I'll
sign your...
judge, I will not sign anything
Okay.
because I am American Indian, not under your jurisdiction. Who
Okay.
give you authority,
So you're
ma'am?
refusing to sign your
I
magistrate's
do not
warning?
understand, ma'am, who give you
Okay.
authority. The courts and
Okay.
judges have been dissolved
all right.
again, January the 4th, 2025. I do request the Attorney General Palm Bandit be appointed. I do request that.
Okay.
And I request that the American Indian Authority be notified as well to you having been charged. And I'm protected of my unidrift and A-drift.
Okay, Mr. Dennis, that's all I have for you to tell you today.
Do you all in regards? There must be a grand jury indictment, not by information, as according to law, course
Okay,
of law,
you're
up under
not-
Constitution.
I'm not holding a trial right now.
No,
that
it
you'll
doesn't
go to
matter,
court
but
on that,
that's in
okay?
the warrant for
I'm
arrest.
just the judge, the
You're not even a
magistrate
judge. All
that
been
reads you your rights
dissolved.
to you, okay?
I'm not under
All
your
right.
jurisdiction.
Mr. Dennis, you
Okay.
can go ahead and return. Thank you, sir.
All courts have been dissolved. All courts.
We will now take up Matthew Shrader on the record now in 2025 TR 1342, State of Kansas versus Matthew Kyle Shrader. Jared Regier for the state. Mr. Shrader, do you appear?
I'm here in pro proper persona, sui juris, appearing specially, not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier, his charges and penalties, please.
Your Honor, pursuant to the information filed with the court on June 13th of this year, this is a case that appears to involve 2 charges. Count 1, failed to register a vehicle, and classified non-person misdemeanor. Count 2, no proof of insurance, and Class B non-person misdemeanor.
And you said these were allegedly committed when, which date, according to the document, the
Your Honor, the charging language in counts 1 and 2 appear to allege occurrence dates on May 21st of this year.
and location within Butler County?
That appears accurate, Your Honor.
Okay. All right, Mr. Shrader, can you still hear me okay?
Yes, I can.
All right, I'm having some issues here, as you can see. In count 1, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
I will waive my right and present myself.
All right, is anyone making you waive your right to an attorney today by any threats or promises
No,
or any other reason?
no.
All right, and you do understand for the record that you do have the right to hire or apply for court appointed if you cannot afford to hire. Do you understand that?
Yes, I'm aware of that.
All right, I will have the record reflect then that you are knowingly and voluntarily waiving your right to an attorney. You're also exercising your right to represent yourself. I'll have the record reflect that in the docket notes and the journal entry. Now then, let's go through these charges. Count 1. Fail to register a vehicle. How do you wish to plead to that? You can plead guilty, and that admits it, and we would proceed to sentencing. You could plead not guilty, denying the charge, and we would set it for trial at a later date. Or the third choice, no contest, means you don't want to admit these charges, but you don't want to admit them, but you don't want to go to trial either. So you'd be pleading no contest. We'd still find you guilty without trial and proceed to sentencing today. Another might be, it's not a plea, but another option might be diversion. The county attorney would offer you diversion if you qualified. You'd have to go online, as I've said several times today to others. You'd have to apply and see if you qualify. They'd send you a response within the next couple of weeks in the U.S. mail. If you agreed to the diversion terms, you would sign the contract and send it back. And if you did everything you were agreeing to, they would dismiss the charge or charges against you, charges if they're both diverted. So, but do you want to divert or apply for diversion? I'm not going to say you get it. I don't know your history, and that would come into play. But how do you want to proceed on the issue of diversion or plea?
Okay, so before we get to that, on the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
All right. You have filed a written motion for subpoena of what documents from the Butler County
Subpoena
Sheriff?
Duces Tecum.
Of what?
There are many items on there, and
so you don't know what you've asked them to bring to court?
yeah, I do. I don't have it in front of me, but it's a lot of the typical things like body cam, dash camera footage.
All right, and they have filed a motion or a response to quash at least part of what you requested.
Yeah.
Right, and Destiny, do you have both his motion and the response on the file there in front of you?
I show the subpoena, Your Honor, and then I show the
Motion.
sheriff's office motion to quash.
Okay. All right. Well, we will set those for hearing if necessary, but how do you want to plead on these charges before we get to that?
Well, I feel like it wouldn't be appropriate to plea until I get the evidence and able to be informed enough to make an appropriate plea.
All right. So you're telling me you don't want to plead not guilty today. You don't want to plead anything today. Is that what you're saying?
Right.
Well, you understand this is the hearing when that happens. We enter a plea at first appearance. That determines what happens from there. But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf, and we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me?
I'm asking you, sir.
How much time I need?
No, I mean, how much time the whole hearing will you anticipate will be?
20 to 30 minutes.
All right, let's be safe. Mr. Regier, have you seen these documents he's referring to?
I have, Your Honor, and what I would tell the court is it would appear that on or about the same time that the written objection to defendant's subpoena Dulcis Teacup and motion to quash was filed with the court, an entry of appearance was also filed with the court by Mr. Terrence Hulskamp, the Butler County Counselor.
And Mr. Hulskamp entered on behalf of the sheriff's office, apparently. Did he file the response?
That would appear accurate, Your Honor, based off of the information in this before the state.
All right, so it sounds like he'll be the one that will be responding to that rather than you, perhaps, just to that limited issue, or do you know?
The written response and motion to quash does appear to be filed by Mr. Hulskamp, Your Honor.
All right, let's set a motion hearing on a Wednesday afternoon. Destiny, what do you have available? Somewhere, I would say maybe an hour at the most. And I know that's a lot on the docket because we have so many other things going on, but
And you do want it on an afternoon, Your Honor?
yes, I think so.
We can put it on with the bench trial dockets and still label it as the motion, and we can block off the rest of that day. November.
I'm sorry, I talked over November what?
Nope, you're okay, Your Honor. November 12th at 1:30.
All right, well, that all sounds good. Okay, I'm ordering defendant to reappear for motion hearing on the bench trial docket, November 12th at 1:30. That will be by Zoom. And I trust counsel for the state will, of course, let all of their attorneys know that need to be here. All right, so that's where we are. And then if we decide we need a trial date, I'll set it at that time, Mr. Shrader. Do you understand that?
Yep, sounds good to me.
All right, if there's nothing further, let's see.
Your Honor, there are multiple matters still to address.
Go ahead, please.
Your Honor, given the statements made on the record today, the state is requesting a ruling by the court as to whether or not this motions hearing is being requested and this matter is being set over by the defense.
Speedy trial time does count towards the defense, and he is asking for this motion hearing to be set and that it be done before trial. And because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, Given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
Anything you want to say about your bond, Mr. Shrader, before I declare it?
I object to that since I appeared here as I was supposed to.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
3,000 OR was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Shrader, you are ordered to appear at the time given by the officers for booking and processing. Your bond will be set at a 3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with Deputy in Court Security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post the 3,000 OR bond, then I very well may have to issue warrants for you. But right now, because you did appear when you were told, I'm going to make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Shrader?
I think I understand it.
Very well. Look for that invitation on the breakout screen. And Destiny, if you'll put that on there for Shrader, for the officer in Court Security 2.
What time? So it's November 12th?
The motions hearing is November 12th at 1:30, correct?
1:30. Okay.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So Destin, if you'll just put the two of them in a breakout room.
All right, good morning. I'm Judge Chungan. We are here on people of the City of Taylor versus Randall Crane. Good morning. I see Mr. Crane up on screen. Sir, I believe you are muted. If you could unmute, please. There we go. Good morning, sir. Would you state your name, please?
My name is Randall Timothy Crane.
Good morning, Mr. Crane. And on behalf of defendant, today we have, please.
James Kazicki. I'm the House Counsel. I spoke with Mr. Crane. We had a breakdown in communications. I don't believe I can go forward representing him. We do not support the same theory of law.
Mr. Crane, sir, you do have the right to have a court-appointed attorney. Do you wish to have a court-appointed attorney, or are you going to represent yourself at this time? You could change your mind later on, but at this stage, sir, are you representing yourself?
Sir, me and the House Counsel do not agree on a bunch of things.
I understand that. My question is, all you're here for today is I'm going to actually give you the formal arraignment and conduct a pretrial. All I'm wondering, sir, is are you going to represent yourself at this limited proceeding? That's all, sir.
I would like to have a assistance.
Okay, all right, but at this time, we do not have other counsel. But what I am going to do is what we call an arraignment. All arraignment, sir, is just a formal reading of the charges that are lodged against you. That's all it is. And I explained that the rights that you have.
Well, I understand my rights.
Hold on just a minute, please. Hold on just a minute. I want to make sure I have the complete file. Mr. Guzicki, maybe you can offer a little assistance, sir. Okay, no, I've got it. So, for the record, Mr. Crane, you're here for an arraignment. As I explained, sir, arraignment is that initial stage of the criminal proceedings, or simply put, you're advised of the charges that are now formally lodged against you. I'm going to advise you of the rights that you have. You'll plead, after I'm done with that, then you plead guilty or not guilty. After that, sir, the next stage is something called a pretrial conference. That's where you, if you're representing yourself, or you with your court-appointed attorney, you sit down with the prosecutor and discuss the merits of the case. Okay, sir. So in this matter, you are charged on the complaint of Taylor PD Officer Schillenberg, who states that on March 26th, while in the city of Taylor, that you obstructed the officer from performing his lawful duties, specifically with respect to the stop on where he claims he observed you operating electronic device. Now, a misdemeanor charge in the state of Michigan. It's a criminal offense. It subjects you potentially to be 0 days in jail up to 90 days. Fines could be 0 up to 500. You could be placed on probation also for a period of up to 2 years. Of course, you have the right to have an attorney to represent you. If you can't afford one, one could be appointed. Of course, you start out with the presumption of innocence. You close with that presumption all the way through, unless and until the jury finds out or a judge rules the other way. Now, of course, you have the right to have a trial. The trial could be heard by a jury or a judge. At trial, sir, you and your attorney have the right to cross-examine all of the prosecution's witnesses. You could bring in witnesses that would testify on your behalf, and you could testify or not testify as you see fit. If you choose to remain silent, it can never be held against you. For example, prosecutor could never tell the jury that, oh, you must be guilty because you didn't testify. We don't allow that, sir. The people have to prove you're guilty, your guilt beyond a reasonable doubt. Now, having heard that charge, how do you plead to the charge of obstructing the officer? All right, I'm going to note that the defendant stands mute. Has the same effect, sir, as you pleading not guilty. Now, sir, you are going to have I need you to write this down, please. You will have a pre-trial conference. So where you're going to meet with an attorney here in the court. You write this date down, July 16th at 9 a.m. It's an in-person pre-trial conference. Furthermore, sir, we're going to mail a notice of that date to the address that's listed on your ticket. Not going to state the address now because this could go out for further public consumption. Not going to do that. But note, sir, July 16th, 9 a.m. All right. And at this time, I'm going to release you on a personal bond. You don't have to post cash. That's your word that you're going to come back on the July 16th date at 9 a.m. All right, sir. Now, I also want to inform you, we have a couple of other charges. They're called civil infractions. One has to do with no proof of insurance. and no registration. Sir, these being civil infractions, you can't be sent to jail for these. They're simply not criminal offenses. All right. You'd be fined up to $100 on each of those, but you can't be sent to jail. Just for your information, they are accompanying charges. So again, sir, today, you've stood mute. I'm going to note you're requesting appointed counsel. I'm also noting for the record you had spoken with Mr. Kazicki and he's not able to represent you any further. And lastly, again, you're on a personal bond. That's your word that you're going to come back on that July 16th date. Understood, sir?
No, I do not understand.
Pardon me, sir?
No, I do not understand.
Well, I'll explain it again. You come back on July 16th in court for a pretrial conference. You meet with the attorney who will meet with the prosecutor. That's when they discuss the merits of the case. And right now, I've released you on a personal bond. You don't have to come to the courthouse and post any money. It's your word that you're coming back on that date. I've notified you here on the record of the court date, and further, you'll be mailed a notice.
Yes, Your Honor, I understand that part, but what I don't understand is I don't understand the jurisdiction that the court has over me.
Sir, you're going to be able to discuss that at a later date. This was just to advise you of the charges formally lodged.
Well, I would also like to advise the court that every day that I am in court, I require $1,400, and I will be charging the court $1,400 for my time.
Sir, you can do as you see fit on that count. I'm just apprising you of your court dates. And with that, you're free to leave the meeting, sir. Thank you.
All right, this is 2509380M, the People versus Randall Crane. We ready on Randall Crane? Mr. Crane's coming up. Hey, you, Mr. Kazicki?
No.
Mr. Crane, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barrett. I did speak with Mr. Crane prior to the court calling the case today. I think that at this time, Mr. Crane's probably best served proceeding is on his own. There are some constitutional arguments that he's raising that I don't think as a member of the bar I can.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for them. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crane. That's a living name, not a corporate fiction.
So you're a real person named Randall Crane.
Person. Okay.
Okay, no, listen to me. Sir, you're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction to the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
you have to provide subject matter jurisdiction as well as personal jurisdiction to me before these can proceed.
Okay, your motion's denied. I have jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right. So, sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
my notes are on.
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here and say them, I can tell you can't have a court. I can tell you can't have a phone in here. I want you to listen to me. You're here today on misdemeanor charges. No talking. You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in the while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device, first offense while operating a motor vehicle, a charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pretrial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pretrial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial. Okay, those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those four options what you want to do. Hire an attorney, speak with court appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir,
exactly
here,
what-
can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your
Your
case
Honor,
back up.
I am asking for you.
Have a seat right now
What
and
was
read
your
your
oath of
rights.
Office.
Have a seat.
Have a seat right now and read your rights, sir. If you
I
don't
read-
understand them, read them.
I move for this court to dismiss.
Have a seat.
Okay, next case. All right, we're coming back up. This is 2509380M, the City of Taylor versus Randall Crane. Mr. Crane, you want to come back up? Mr. Crane, did you have a chance to go over your constitutional rights that I provided to you?
Yes, I understand my constitutional rights.
Okay, thank you, sir. So at this time, I gave you four options. Would you like to retain your own attorney? Would you like to speak with House counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Or would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else? There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney,
I understand
a
that,
court-appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain, listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the four choices I gave you, which one would you like to do?
I am required to understand everything in regards to my case,
Okay.
including subject jurisdiction matters.
All right, well, you could do your
personal
research. I'm
jurisdiction.
setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do: waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in, you're going to try your case. Again, if you want to talk to House Counsel, you could do so. All
I'm
right.
not wasting the city of Taylor's time.
Okay, good. We'll
Okay.
see you on your trial date. Have a good day.
Well, guys, we've come to the end of both of these proceedings. Not going to say much on the first one since I've already talked about that. But as we can see in Mr. Crane's second appearance, his most recent appearance before Judge Shackelford, you know, his attorney says, listen, we're not going to be able to do this. It's not going to happen. You know, we have different views. I'm not going to, you know, put anything before the court that the court is not willing to accept or that can get me in trouble. So, you know, they decided to part ways. But as we can see here in the second appearance, Mr. Crane tried to be a little bit more aggressive than he was that first time. But Judge Shackelford, being the veteran that she is, pretty much shut him down, you know, gave him his, you know, his constitutional rights so he could look it over, shut him down for a minute. He tried to come back and get on the same stuff. She wasn't trying to entertain it. It's going to be interesting and seeing how his next appearance goes, especially with him representing himself and especially with the ideology that he has and, you know, all of the arguments that he wants to make. And we see some of his motions got shut down. So it is what it is. Not much to say on this one. I mean, you saw it for yourself. And with that being said, I am looking forward to seeing his next appearance. As always, I appreciate you guys for joining me. This is Sovereign Citizens Hall of Fame, guys. And until the next time we get together, guys, for now, Sovereign Citizens Court is adjourned. I appreciate you guys. See you guys soon, and God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.